example I use is a really cool case that it was in my thesis, my doctoral thesis, and I really think it's a very creative and smart approach to making a human rights complaint that's more systemic. And so basically wheelchair users in Nova Scotia, instead of complaining about inaccessible restaurants that they couldn't get into or they couldn't use the washroom, they actually complained to the Human Rights Commission in Nova Scotia about the way that restaurants were receiving permits despite the fact that their hand washing facilities, which is part of the restaurant licensing regulations, their public hand washing facilities were not accessible to wheelchair users. So the provision in the regulation says there must be public hand washing facilities that are accessible to the public. Well, the restaurant permits were being given out without regard to wheelchair users as part of that public that needs to be able to wash their hands. And so they were really successful at they had to go to court because the commission refused to support the complaint because they were saying, oh, this is a building code issue. This is not human rights law. But actually the wheelchair users won, even though the commission wouldn't give them any support as what they're supposed to, take the case, and the lawyers from the commission are supposed to support the complainant when it goes to court, in this case, a board of inquiry. Anyways, they were completely unsuccessful, and the board of inquiry looked at the fact that wheelchair users have dirtier hands, maybe because they're pushing a chair.
Yeah.
And if you treat, and you can't just say the members of the public, we're only thinking of able-bodied. So it's really smart, and it led to a huge change in building code in Nova Scotia, such that you can't open a restaurant in a building that's not accessible. So that's actually very different from the way building code works in the rest of the country.
Mm-hmm.
In the rest of the country, building code is usually, if you happen to be in an older building, then you're not required to bring it up to code unless you do a major renovation. So if a restaurant chooses an older building, they're not necessarily going to have to make it accessible because that's not retroactive. But this change to the building code said, no, actually, if you are a restaurant owner and you want to have a restaurant, you must pick a place that's already accessible, or you'll have to make it accessible. Wow. So it's really cool because it also shows that it's like restaurants, just because, election spaces, schools, hospitals, those are places people think, oh yeah, that better be accessible because people with disabilities have the right to vote and these are important rights. But this case is like, no, actually also people should just be able to use the washroom and go to restaurants too. Mm-hmm. And so it's important, I think, because it's a step towards treating, when we talk about the public, that means people with disabilities too.